Lyft has been sued by rapper Dank Demoss, and I know what some of you are thinking.
Oh, another rideshare lawsuit? Haven't we seen this before?
But trust me, this one's different. This case isn't just about a canceled ride. It's about access to public services and whether tech companies can be held responsible for discrimination that happens on their platforms. Join me, America's attorney, a lawyer for over 20 years, who's given legal rides to over 160,000 clients, while I break down the allegations in this civil rights lawsuit, because the allegations are, they're hefty, and they're also kind of crazy. Let's jump right in. We'll start with what the lawsuit claims occurred just 1 month ago. It's football season, and rapper Dank Demoss, legal name Dajua Blanding, is headed to her cousin's house for a watch party. Like most of us these days, she pulls out her phone, opens the Lyft app, and requests a ride. As an aside, I can't be the only one that thinks that Lyft prices are so much better than Uber's for the last couple of years, right? Let me know in the comments if you agree. Anyway, after about 10 or 15 minutes, a Mercedes-Benz sedan pulls up. Seems nice. Now, this is where things take a turn that nobody would have expected. As Blanding approaches the vehicle, and folks, this is how she documents it in the court filings. The driver, identified in the complaint as John Doe, allegedly does something shocking. He locks the doors and tries to drive away. When Blanding, understandably confused and shocked, asks what's going on, the driver reportedly tells her something that would become the centerpiece of this lawsuit. She was too big to enter his vehicle. Not only that, but he claims his tires weren't capable of supporting her weight. According to the filing, when Blanding protests, explain there's plenty of room in the back seat, the driver doubles down. He tells her this isn't his first time dealing with this problem and informs her that overweight individuals must order Lyft XLs. But how does that incident, however nasty or funny you may find it, violate the law if it does? Well, the heart of this lawsuit beats with Michigan's Elliott Larson Civil Rights Act, or ELCRA for those of us who love a good legal acronym. ELCRA is one of the most comprehensive civil rights laws in the country. Under ELCRA, public accommodations, that's fancy legal speak for businesses open to the public, and it definitely includes rideshare companies, can't discriminate based on a whole host of characteristics. And here's the kicker. Michigan's law goes far beyond federal protections to explicitly cover weight discrimination. You heard that right. Michigan is one of the few places where weight discrimination isn't just morally questionable, it's actually illegal. I thought that would be only Louisiana and Mississippi, but whatever. Now, this case isn't just filing one claim. It's coming at Lyft with a double-barreled approach. First up, hostile environment. Think like workplace harassment, but in this case, it's about creating an unwelcoming environment in a public service. Second, disparate treatment, which is basically legal speak for treating someone differently when you shouldn't. So with these claims in mind, we understand why they are coming for John Doe, the Lyft driver. But why sue Lyft? It's not their policy, to my knowledge, to deny rides past a certain weight limit. The answer comes from a legal doctrine called respondeat superior. This legal principle basically says companies can be held responsible for their employees' actions while on the job. But, and this is a huge but, Lyft classifies drivers as independent contractors, not employees. However, the complaint argues that regardless of how Lyft classifies its drivers, they're acting as Lyft's agents when they're picking up passengers or not picking them up and driving away, as the case may be. Well, think about it. Who arranged that ride? Lyft. Who processed the payment? Lyft. Who set the rules? You guessed it, Lyft. Legally speaking, it may be a non-issue that Lyft and John Doe agree that he is an independent contractor if, in the eyes of the law, John Doe is carrying out the work of Lyft. Then Lyft may be on the hook for his activities. When I first saw the headlines, I thought,
this is such a loser of a case.
Being fat is not a protected status under federal law, and therefore the case is dead on arrival. But then, digging into it, Michigan law is far more protective towards people of great gravitational force than is federal law, which means that the claim probably has facial validity and cannot be dismissed on summary judgment. But that's only the basic elements of the claim. Then you have this issue of whether Lyft can be correctly charged with the alleged misbehavior of the driver, who is this independent contractor in the state of Michigan. However, there's a wrinkle on top of that because in Lyft's home state of California, the driver may very well be considered to be an employee. And certainly there is litigation all over the country and has been for 6 or 8 years about whether the drivers of rideshare companies are employees of the company or agents of the company for purposes of liability, just such as this. I can tell you from my observation of the years and years of that litigation that these rideshare companies are doing everything that they possibly can to get a legal determination that they are not responsible for the things that the drivers do and don't do. But those efforts in court are largely unsuccessful, which means that even if this driver violated a policy that Lyft has in writing regarding its drivers, Lyft itself may still be on the hook for any judgment against the driver. In fact, the very existence of a policy by Lyft that instructs its drivers to not decline to pick up a passenger based on the passenger's body mass index likely means that Lyft is acting more like an employer and not like an entity engaged with an independent contractor. For that reason, Lyft is very likely to be unwilling to agree that the driver was acting on its behalf when it discriminated against the rapper based on her incredible girth. But there is another wrinkle on top of that, because both the driver and Lyft have a pretty nice argument that they weren't refusing to give her accommodation, but instead wanted to supply her with the correct vehicle to accommodate her. Meaning that instead of denying her services, they were trying to protect the vehicle and give her a better experience. But this argument doesn't mean that Lyft wouldn't be willing to write a check to make the lawsuit go away. In fact, the opposite is probably true. That because they could be determined to be liable for the acts of the driver, and the driver's behavior, while legal under federal law, was an apparent violation of Michigan state law, it's not hard to imagine Lyft writing a check to the biggest rapper of all time. And I don't mean the most successful rapper of all time. I'll let you figure it out. But how big of a check are we talking about? It would not be hard for me to imagine that a jury would take great satisfaction in ruling in favor of the rapper and giving her somewhere between like 50 and $100, meaning they just want to give her enough to put her on a meal plan for a week to get her headed in the right direction. Of course, I'm just joking. But the driver didn't injure her physically, and she would only be just a little bit delayed in going to the party if she ordered another car. So she doesn't really have a lot of damages, and therefore it may be hard for her to garner sympathy from a jury. Of course, if the jury is stocked with people who are rabid fans of her music, then maybe they want to give her a lot of money. Or as I like to say, give me that cash. But I wouldn't bet on that. So as I was saying, when I first heard about the case, I thought it was a loser because being fat is not a protected status under federal law. Then I did some legal research and I learned that being fat is a protected status in Michigan, which makes me think that I might want to retire there someday and start eating hamburgers like every single day. But it also makes me think that I need to try to figure out what this case might actually be worth, since it is clearly not only worth zero. And I think the answer is that it's probably worth a couple $1,000s and an apology if I were the lawyers for Lyft. And if I were the lawyers for Lyft, which I'm not, I'd be willing to go to trial and concede that, hey, okay, the law was broken. And I'd argue to the jury that she's owed just a couple $1,000s. And on top of that, I'd argue that if her lawyers want a lot more than that, then this is just one of those fake lawsuits that makes the legal system look bad. And then I just take my chances, because there are many, many groups of 12 people in America who would not be persuaded to give lots and lots of money to someone just because a taxi drove away without picking her up. How do you think this lawsuit will end? And what are your thoughts on the validity of these claims? Drop your pro se opinion down below and let me know what you're thinking. And don't forget, while you're down there, to lawyer up with America's Attorney by hitting that subscribe button. And if the button is too small, or if your hands are just too plump, just mash the subscribe button and all the buttons around that area. Because I'll be back soon with another legal breakdown, and I don't want you to miss it. Dank Demoss, aka understandably confused and shocked, goes far beyond federal protections to explicit